You've got a filed lawsuit and you've just learned that you're going to have to submit to a deposition. My name's Dan Burke and I'm a lawyer at Parker Waichman in New York, and we represent thousands of clients, many or most of which ultimately go through depositions, and we will spend the time with you to prepare you for your deposition and get you familiarized with the types of questions that you'll be hearing so that you're not surprised when you're answering the questions. What types of questions can you expect if you've got a personal injury case? Well, typically the defendants take folks through questions in three primary stages. One is to get a big background on you. That'll be asking you questions about all the addresses where you've lived, what you've done since you were a child, childhood, family issues, family history of particular diseases or problems, and so forth, your employment history, things like that. Secondarily, they will typically take you through your past medical history, and they could spend a lot of time doing this. What diseases you've had, what medical conditions you've suffered from, have you been in any accidents, have you been injured in any way similarly, and these are designed to detect whether or not there's an alternative cause from the injury that you're claiming in the lawsuit. Then they will get into your present medical condition and ask you a number of questions concerning what your allegations are in the lawsuit. When did you begin taking the drug or using the device or using the consumer product that you're alleging is causing your problem? Once they get through those questions of when you began, what problems did you begin to develop, how did they begin to develop, and how have they evolved through time? There are a lot of tricky areas and pitfalls in these types of questions that are designed to trip you up and that the defendants will use to potentially try to knock your lawsuit out. One such issue is with respect to statutes of limitations. In New York and in every state in the country, there are periods of time in which lawsuits have to be commenced. And defendants will try to get you to say that you learned of the dangers of a drug or the problems potentially associated with a drug or a device long before you actually had any idea, or that your doctor had any idea, in an effort to get your case dismissed on statute of limitations grounds. Also, with respect to drug cases especially, one of our main claims are failure to warn. This company, although they put out a drug that benefited you, failed to adequately warn you as to what the dangers of the drug were, and you weren't able then to make an informed decision as to whether or not to take the drug, and therefore you suffered an injury. These questions are crucial when it comes to failure to warn. What did you do in terms of making the decision to take the drug? Did you read the label? Did you ask your doctor's questions? Did you read the little handout that comes from the pharmacy? When did you become aware of these things? Would you have taken the drug had you known? These are the types of questions that when you sit down with your lawyer to prepare for a deposition, and mind you, you will never submit to a deposition without sitting with your lawyer and preparing first. These are the types of questions that will walk you through and answer for you and give you some familiarity with before you ever have to give testimony. Chances are you're watching this video because you have concerns as to what the process will look like and what will happen if you do bring a lawsuit and if you have to submit to deposition. We're happy to answer your questions. Pick up the phone and give us a call. Again, my name's Dan Burke. I'm a lawyer at Parker Waichman in New York. Thanks so much for taking the time to watch.